The committee will come to order. Clerk will open the roll.
Mr. Chair, you have a quorum.
All right. First order of business, we've got judicial elections coming up at some point or another, presumably tomorrow or at some later date. We have interviewed 9 candidates for juvenile and domestic relations court positions, 5 for general district court positions, and 6 for circuit court positions. And have that list. I don't know whether we have copies of that list. I can read through them if you have questions, but these are the judicial candidates that we interviewed. We need to certify so that at an appropriate time we can proceed with elections. So the list is before us. Richard?
Mr. Chairman, there's one I'd like to remove from the juvenile court block, and that individual is Jonathan Frieden.
And my understanding is your request is not to vote on him today, but just defer.
Correct. Just remove him from the block and take no action today on that particular
That's
candidate.
to pass it by for the day. So
Yes,
we can
Mr.
take it up on the floor if
Yes, Mr. Chairman, that's
appropriate.
exactly what my...
Okay.
And I appreciate, and Mr. Chair, if I might just interject, I do have a letter from Mr. Frieden to address concerns, and obviously I'll be happy to take them up with the member.
Sure.
Thank you.
All right.
And Mr. Chairman, that's all this is to do, is just so we could discuss this a little bit.
Okay, Senator Stewart, without objection, Mr. Frieden will come out of the block. Is there a motion to certify the remaining candidates?
So moved.
It's been moved and seconded. Clerk will open the roll. All right.
Ayes 12, no zero.
All right, we're short a few patrons, but I think we've got a handful of bills that we can click through. Kristen, you have one teed up for us?
The first one, Mr. Chairman, House Bill 128, and I believe it's a Boyd Graves bill, and their lobbyist is here who can present the bill.
All right, Jeff?
Oh, before we start, I'm sorry, Mr. Chairman. There was a concern in work group that was raised about the language that House courts had added on line 13 of the bill, and there was just a grammatical issue with it. In the meantime, Mr. Palmer also brought up the fact that the creditors bar didn't like that the bill applied to courts not of record because of the different pleadings practices between the courts of record and courts not of record. So they recommended that we limit the bill's applicability to courts of record. I have a substitute that would achieve both of those issues.
So basically, I mean, and it's been a long time since I've been in general district court on collections matters, but my recollection is it's a pretty streamlined process for show cause in general district court, and the desire is to essentially formalize the process, provide for a petition, and an affidavit, is that right?
Correct.
For show cause proceedings in circuit court.
It could
Is that
be,
it in a
yes,
nutshell?
Mr. Chairman, it could be a motion, petition, or form accompanied by an affidavit, and it's my understanding that the judicial conference is supportive of this measure as well.
All right, anybody have any concerns or questions about this? Senator Edwards.
I have a fair amount of experience in a lot of courts. And now, I don't know about the substitute may be better, but it only applies to courts of record, I believe.
Correct.
But my experience is the only time that I've seen it done is in domestic cases. And to have to jump through these hoops is just going to run up a bill and take more time. Maybe that's the reason somebody wants it, but I don't think it's necessary. I'd like to find out why is it that we have to make all these requirements and or just on a show cause case. I assume, Mr. Chairman, is you want to put somebody on notice, absolutely. But typically you can do it without having to file all these. You got the motion, then you got it. I think you have to show particularities. I haven't read the whole thing yet, affidavits and all that. That is, in my experience, has been it just is unnecessary. Can you explain why it was
Well,
even recommended?
so the Boyd Graves Conference looked at, they were trying to pinpoint what exactly is required for a rule to show cause, and there's no statute, no general rule, no procedure for a rule to show cause. And so they felt it would be helpful to have a statute that said very clearly what is required by the parties to present and for the court to consider in such a case. And yes, you're correct. On line 14, it says the motion or petition shall include facts identifying with particularity the violation and have an affidavit. But we don't think that that is a high burden at all. It's just a motion or petition. This is not designed to run up anybody's costs at all. It's just supposed to set very clear standards for what is required in these cases, because there's absence of any clarity right now.
Mr. Chairman?
So this is for contempt. I mean, before you hold somebody in contempt of court.
Mr.
And-
Chairman?
Right.
Can't,
Sarah Edwards.
on an individualized basis, somebody requests particularity, and I'm sure the judge would order it. Just sort of on not across, here, this makes it across the board.
Well, if you're required to have an affidavit to show facts, I don't know why you wouldn't have particularity as a requirement
Well,
for
Mr.
what the affidavit
Give an
includes.
example, Mr. Chairman. It's routine in domestic cases to file a motion to hold one of the other party in contempt for not paying child support, for example. And it's usually just fairly simple, as opposed to having to file an affidavit and all that kind of thing. What kind of cases require this type of particularity?
I can only say that this was the consensus view of the Boyd Graves Conference, that there needed to be some clear boundaries for what should be provided to the court in these cases.
Mr. Chairman,
and this was
can't
their
this
view.
be done on a rule
Senator-
basis too, by
Senator
the Supreme
Edwards.
Court? Has the Supreme Court require, adopt some rules on this?
And yes, Mr. Chairman, the Boyd Graves Conference looked at that issue, whether this would be appropriate as a rule or as a statute, and felt that a statute was best in this case.
I'll just vote no.
Okay. Senator Chafin.
Mr. Chairman, I just comment on the bill. I practice probably in about a 12-county area, and in those counties, this is the way it's done. I mean, this is the way it's done. If you want to get a show cause issued, you've got to go through these procedures, or it won't happen. And also note that this is what is contained in the bench book. So this is what the judges are looking at to make sure that it happens.
All right. Senator Stewart.
Thank you, Mr. Chairman. I think this just clarifies and provides for a clean, easy way to enforce these court orders, which many courts already do, and clarifies it across the state. I'd move to report the bill.
Second.
All right, it's been moved and seconded. Before we take the vote, just let me ask, is there anybody in the audience, or do you know of anybody other than Senator Edwards who objects to this?
No, I have not heard from anyone, and no one spoke in the
All
House.
right. Motion to report is before us. Clerk will open the roll. All right, thank you. We've got Delegate Toscano here. House Bill 1246.
Thank you. Last time I was here, my bill was ruled unconstitutional, so so I'm hoping that doesn't happen today.
Is that Judge Benjamin?
That's right.
Mr. Chairman, this looks excellent.
1246 is a bill related to identity theft and issuing the identity theft passports. I think you know that this has been that program has been in operation for a while, but this would make it a little bit easier to get one of these passports. Currently, the code only allows passports to be issued if a victim of identity theft has petitioned the court for expungement of a criminal record because the identity was stolen and used while committing a crime. Now, this would allow the issuance of the passport if law enforcement has been contacted about the threat and that law enforcement has passed along that information to the AG's office. I think there were some concerns about fiscal impact. I think those have been resolved. There's no FIS on the bill itself, and I think Senator Openchain may also have talked to Jay Lark about it, so I think we're okay with that. So we have people here from the AG's office to speak to the bill if you would like to hear from them.
Why don't we see if anybody is opposed to the bill? I'm not aware of any concerns. It appears to be in good shape.
Mr. Chairman, I move the report. Second.
All right.
Thank you.
It's been moved and seconded to report the bill. Clerk will open the roll. Guess I could do that.
Thank you.
All right, thank you. And Kristen, you have another for us?
Mr. Chairman, 1023 is also a Boyd Graves bill.
Mr. Palmore.
Who is this Boyd?
Yeah, I hate
Yeah, who's Boyd
Who is
Graves?
this Boyd Graves?
Money Boyd, Munford Boyd. I'm doing well.
So 1023 deals with foreign subpoenas issued under the Uniform Interstate Depositions and Discovery Act. And there is, again, a lack of clarity in how those subpoenas are issued. And it was the view of the Boyd Graves Conference that it would be helpful for the code to clarify that subpoenas issued from a foreign case when they're domesticated here in Virginia are issued by the circuit court clerk in the Commonwealth, and the Court Clerks Association is supportive of this legislation.
So these are out-of-state subpoenas being issued and served in Virginia.
Correct.
Under the act. So if they have local counsel in Virginia, this would still require them to be issued by the clerk and not by that local counsel.
Correct.
Okay.
Mr. Chairman.
Senator Peterson.
Okay, let me give a real-world example. Let's say you got a judgment in a foreign state and you domesticate it in, let's say, Fairfax County.
Right.
Are you saying that I had to have to get the clerk to issue the subpoenas to do garnishments and to get discovery and all that good stuff?
Yes, Mr. Chairman, because that, once that's domesticated here, it is, for clerical purposes, it's best for those to flow through the clerk because there could be other issues that come up around that case or with your challenging the subpoena, that it's helpful, because otherwise there may not be a docket number or a case before the court. So this would be initiating the case in Virginia so that everything that resolves around that is kind of flows through the clerk.
Okay, one more follow-up question, Mr. Chair.
Senator Peterson.
Well, I can domesticate a case and I can open up a case number. If somebody wants to file a motion to quash, they could still file the motion to quash. I'm not a big fan of, I mean, we've already heard from clerk's offices, they got too many things to do already. Attorney-issued subpoenas is one of the great benefits of Virginia practice. You don't have to wait at the clerk's office for weeks to get a subpoena issued.
I think one of the issues, Mr. Chairman, is that the Uniform Interstate Depositions and Discovery Act has requirements in it for out-of-state subpoenas, and it is helpful before those subpoenas are issued for the clerk to evaluate whether the subpoena itself meets the requirements of the UIDDA before those are issued, because once those are issued, it's kind of hard to get the horse back in the barn, and so the clerk at the outset can evaluate to make sure that it meets the requirements of the statute before those are issued, and then, as we said, make it easier to track subsequent procedures to challenge or enforce the subpoena.
Okay, final follow-up question, Mr. Chair.
Final question.
Final. You're saying the clerk is the gatekeeper of whether or not the subpoena will issue. Are you saying that they're going to determine whether or not it's outside the scope of discovery or it's relevant? I mean, again, the adverse party can always file a motion to quash.
No, Mr. Chairman, I'm only speaking to the specific requirements of the UIDDA. And I can pull them up, but I don't have them in front of me. But there are specific requirements that apply differently to an interstate deposition or interstate subpoena under the UIDDA than would apply under a Virginia subpoena. And so just making sure that the requirements for the UIDDA are met before that gets issued was the view of the conference that would be helpful. Thank you.
All right, anybody have any concerns about this other than Senator Peterson? Is court okay with this? Okay. Thank you. Bill's before us.
Move to report.
It's been moved and seconded the bill be reported. Clerk will open the roll.
I think, it gives you
Ayes 12, noes 1.
All right. Next, Delegate Adams. I'm sorry, Campbell.
Looking around, Mr. Chairman.
He's in the queue. You and Delegate Adams. We
Mr.
got
Chairman.
1454.
Yes, Mr. Chairman, members of the committee, this bill originates out of a local work release program back in our area that has been wildly successful. It saved Russell County about $250,000 in incarceration costs last year alone. The rest of the localities in the area are looking at it as a model to implement. One of the obstacles in the expansion of the program, however, has been an expressed concern by employees and operators and nonprofits with respect to liability that may flow toward them from the probationers if they were to employ these individuals.
So right now, we've got civil immunity that exists for government employees, probation officers, court personnel, other public safety officials in connection with utilizing and deploying probationers for work release or work details or community service. This simply says that if a nonprofit is utilized for providing those services, they have civil immunity to those probationers for all but willful or gross negligence and willful misconduct.
Right. The original bill actually contemplated blanket immunity. I thought that was a bridge too far.
Blanket immunity?
As did the trial lawyers, and we amended it to qualified immunity.
All right. So, anybody have any questions of the patron? Anybody in the audience have concerns about the bill? The bill is before us. It actually, I am. All right, is there a motion?
Move to report.
It's been moved and seconded that the bill be reported. Clerk will open the roll.
Thank you, Mr. Chair.
All right, thank you. Jeff, you have one more Boyd Graves bill? That was it? Okay. Kristen?
Mr. Chairman, on page 2, House Bill 996, this is Delegate Gilbert's bill. It is identical to Senate Bill 783, which was Senator Peak's bill, which was reported from this committee 15-0 and passed the Senate 37-3.
Is there a motion to report that bill? It's been moved and seconded. Clerk will open the roll. All right, that bill is reported. Delegate Leftwich, you have another easy bill for us today?
I hope so. So,
741.
yes, sir. So this was brought to me by a
The
constituent.
family, or the Trust and Estate section of the Virginia Bar Association?
No, I promise, none next year either.
augmented estates.
Okay, so, again, a constituent and a labor attorney in my district brought this to me. And essentially what it says is that investigations conducted by the Department of Human Services, that material and findings would not be admissible in a court of law.
Actually, it's just the determination, isn't it?
Determinations, yes.
Not the investigation. And
Right.
When I first looked at this, I was concerned. I've tried to discover the results of investigations conducted by certain state agencies, and they may, in some instances, be the only ones who have access to that information that disappears, and I'm concerned about blanket protections for that, but the rationale here is it's just an
The integrity of-
informal
yes.
determination, and it shouldn't have any significant
Correct.
precedential impact.
That's it. And
Okay.
it's my understanding that the Employment Commission operates under that process now.
All right.
So this would parallel to what.
You aware
they
of
do
any
there.
opposition to this?
I'm not aware of any.
Well, Mr. Chairman,
Sarah Edwards.
I can, it may not be admissible in evidence, but it ought to be discoverable unless there's some previous reason why it was given in confidence. But this is an informal determination of the division. And why shouldn't it at least be discoverable? You may learn something from listening, being, learning about it.
And if I can follow up, quick question. I've never seen one of these. Do they contain detailed findings of fact, things that may be helpful in discovery? Do you know?
I do not know, Mr. Chairman.
Anybody here? Okay.
Well, Mr. Chairman.
I would guess not.
Mr. Chairman,
Sarah
under
Edwards.
subdivision A, you can't make public something that's confidential. Investigative notes and other correspondence that is confidential, presented as confidential, but B is the informal determination prior to the public hearing. It should be at least be discoverable, and because you're going to go to a hearing, and this could be helpful to both sides, maybe.
So I think the rationale behind that, Mr. Chair, speaking to the chair, but in response to Senator Edwards' question. So this is an informal, be analogous to a bar situation where they investigate someone who's had a complaint filed against them, it's dismissed. And so do we want people discovering complaints that are unfounded? And this is all prior to the public hearing. Once it hits the public hearing stage, then it's a whole new ballgame. So if people make complaints against people all the time, some are founded, some are not founded. In that investigation, I think what we're trying to protect that. And then once it gets into a courtroom, over complaints filed, lawsuits filed, despite a public hearing being held, then do we want all that stuff coming in that was informal, hearsay, third party?
Well, Mr. Chairman, maybe you should fill this in. What, the Division of Human Rights, what kind of things are they talking about?
Would be any type of form of discrimination.
Yeah, that's what I'm saying, but
Sarah Edwards.
you could, you follow the same thing for the EOC in federal.
Could.
And so I don't think that's confidential. I'm just trying to figure out why it's not presented, the informal determination is that an confidential meeting of the board or something, or?
No, it's not confidential. It's just, Mr. Chair, it's from my understanding, talking to the individual who brought the bill to me, is that a lot of this, complaints made, some are founded, some are not founded. They go out and conduct an investigation. It's hearsay. The third parties may not be reliable in all situations. And, do we want to?
They could be wrong.
Wrong.
So you can discover the facts, interview notes, statements, pictures, or other material in the file. This doesn't protect that. It just protects the informal determination, the preliminary informal determination.
Well, under A, Mr. Chairman, under A, it's
Sarah
the
Edwards.
notes and other correspondence and information furnished to the division in confidence. I get that to be confidential, but I don't know why the informal determination. Why do they even have an informal determination?
Well, I think A says, Mr. Chair, that stuff be held in confidence. They can't publicize it, but Section B only deals with the informal determination, not once they've made a ruling. It doesn't say that, there's a difference between something being made public and something being discoverable, I guess is the distinction I'm drawing.
Well, that's it. I mean, not
Sarah
being
Edwards.
public, Mr. Chairman, not being public is one thing, but not even being discoverable. Maybe it ought to be discoverable under a protective order, maybe, or
So
something.
you think it should be discoverable? You
I
don't
think
like
it's
it?
discoverable, yeah.
Okay.
So again, Mr.
All
Chair,
right.
may I?
Any other concerns? Is there a motion on the bill?
Move to report.
Is there a second? It's been moved and seconded that the bill be reported. Clerk will open the roll.
Ought to be discoverable. There you go. You guys are.
Thank you, Mr. Chairman.
You'd be a better human being.
Thank you.
Maybe some more work to do.
You'd be a better human being.
Oh, you're doing just fine. Delegate Mieres.
Guess I'm bringing up the rear, Mr.
166.
Chairman. How are you, sir?
I'm well.
Okay, 166. This is a bill recommended by the Virginia Circuit Court Clerks Association. Simply,
Hyper-technical
right.
bill. It simply allows the bond books. Is that right?
That's correct, Mr. Chairman. It allows the bond books to list books for which a microphotographic process, which is the shrinking of photographs to a microscopic scale, may be used to record writings otherwise is required to retain in a large book form in the clerk's office.
Really digital.
Essentially, yes, Mr. Chairman, and repeals an obsolete section of the code that required circuit court clerks to keep a log of documents submitted for recordation that had not been recorded. It also raises the age for claiming exemption from jury service from 70 to 73 years of age, and also allows the clerk of an appellate court to request a paper trial court records. And it was a pleasure of this committee to pass the bill.
Mr. Chairman,
Senator McDougal.
Yes,
would you mind if we prohibited certain companies from requiring that we use their transcripts for recording proceedings?
Mr. Senator, I would perhaps leave it to the discretion of the chair.
Not my call. Court is fine with this. What? I don't see a need to pursue that line. All right, the bill is before us. It's been moved and seconded the bill be reported. Clerk will open the roll. All right.
That's 13-0.
And just for the chairman's, for the committee, if they need to do a motion to reconsider, they can. I just was reminded that section of raising the age on the jurors actually was removed in the House and committee. I had forgotten about that, and I apologize. Other than that, everything else in the bill is the same.
I'm sorry.
Yes, sir.
Sir Peterson?
Never.
All right. Is that it?
I have HB 128 as well.
Didn't we do that?
We've already handled that.
It's dead.
Thank you, Mr. Chairman.
You're good. All right. Next, what do we have?
Mr. Chairman, House Bill 1550, Delegate Adams' bill raising the larceny threshold, similar to Senator Suderline's. The differences in the catch lines, and HB 1550 is the correct version.
HB 1550 is, all right. Sir, motion, anybody have any questions? Anybody?
Is this, Mr. Chairman, is this identical to the one we passed out?
You said it was a little bit different.
It's identical except for a minor discrepancy in the catch line, which is being fixed in Senator Suderline's version. We caught it when Delegate Adams' version came over.
All right, it's been moved and seconded the bill be reported. Clerk will open the roll. You've got Reeves and Stanley. Stanley's for it.
There were 3 no votes on the House, on the Senate committee.
Okay. So how about 986? Can we do that? At least give it a try, see if anybody has any. Did you get a response from Delegate Gilbert? You did not? Huh? You want to text him and ask him if he's okay with the amendments that Kristen emailed to him twice? All right, another bill? I see we have Mr. Delegate Dix here, so maybe one of his bills.
Mr. Chairman, 1238 Delegate Klein's bill on page 3.
All right, let's do 1238. Charles or Steve?
Mr. Chairman, House Bill 1238 basically just corrects a provision that provides a person who is in jail that it clarifies that if he cannot be released. Current law allows him to be released if discharged, if the indictment or information has not been filed before the end of the second term, and this just eliminates that provision. It eliminates his release. So in other words, if a person's in jail on a criminal charge and it has been certified or otherwise transferred from district court to circuit court,
A clever defense lawyer can't obtain his release.
that's correct.
That's not fair.
Mr. Chairman, I wondered why this was necessary. You see, in the existing language on line 13, it says if the indictment has not been returned by the second term of the court at which he is held to answer, that's
Tell you what, if we've got issues, let's wait until the.
Don't have an issue. I don't see that the bill does any harm. Exactly.
All right, how about the Commonwealth's attorneys?
Mr. Chairman, may it please the court, David Ledbetter, Commonwealth's Attorney of Waynesboro for the
Court is
Virginia
very
Association.
pleased.
I'm sorry, long week, Mr. Chairman. This is just a clarification that this section only applies in circuit court proceedings. There's some belief out there that it applies to general district court proceedings, and some district court judges have said if 2 terms of the circuit court have passed, they're releasing people out of district court. Somebody may be still pending preliminary hearing, and it's very often that preliminary hearings may get set out 90 to 120 days and 2 terms of court pass by.
So this is an actual problem, not just a theoretical.
It's a real problem. It's happened. In the 25th Judicial Circuit that has been occurring on an ongoing basis. We make the argument. If you look at this code section, this section was last modified in 1970 before district courts even came into existence after the 72 constitutional revisions. And so there is an actual problem. Some courts are reading this as applying to district courts, even though there are no terms of court of district court.
Steve, Charles, any problem?
There's no problem with the bill. I'm just surprised that it's necessary, but I accept those representations.
Mr. Chairman,
Scholars on the bench.
yeah, Mr. Chairman, do courts have terms anymore?
Mr. Chairman, circuit courts certainly have terms, but district courts do not.
Okay. I didn't know circuit courts.
Anybody have an issue? Because if you do, we're going to get the patron up here. Otherwise, we can report it out.
I would move to report, Mr. Chair.
Okay. It's been moved and seconded that the bill be reported. Clerk will open the roll.
Ayes 14, no zero.
All right. Nothing else easy. Campbell. Yeah, let's talk to Virginia Department of Transportation and the Attorney General's office.
Mr. Chair, Joanne Maxwell from VDOT. We're here about SB 995. We explained the bill last time we were here, but just briefly to reiterate, what the bill does is clearly articulate in what has basically been the longstanding policy and practice of VDOT to allow only certain signs in the right-of-way. Namely those signs that relate to public safety, that relate to public information, or that provide directions, but not other signs. Again, this legislation is brought in response, or being brought in response to a constitutional challenge to VDOT statute that basically prohibits signs in the right-of-way. That has been challenged, and what we're trying to do is clearly articulate some exceptions in the code that are provided to make sure that our practice is being adhered to, and to make sure that no one can argue that we're allowing other than only those very restrictive signs in the right-of-way.
And just to refresh recollection, one of the issues and concerns is the pending litigation. Also, a question was raised about whether, in fact, if we are subject to an adverse ruling, whether court will or would likely stay that ruling pending appeal, and also the adverse consequences of the court declining to do that. Senator Stewart, you had a question?
Mr. Chairman, Joanne, we discussed this yesterday or the day before. Again, were you all able to determine whether or not the governor has any authority to act in the event that we get an adverse ruling and we're out of session, to act and take any action until we can get back into session?
Mr. Chair, we've not been able to get a definitive answer on that issue. We do have concerns that generally the governor's power under executive order does not exceed what's authorized by law, but that would be something we'd have to defer to the AG's office on ultimately.
Did you look, were you able to look at that any further after we discussed it?
It's still under review, Senator. I apologize.
Mr. Chairman,
Sir Edwards.
I move to report. It seems to me this is one of those situations where we basically know what the judge is going to do. Basically, the Commonwealth is saying, yeah, you're right, we ought to correct this. That'd be a wise thing in this, in my opinion, in this case, to go ahead and approve pass the bill and clarify the matter once and for all. So I move to report.
Oh, my God. All right, so you moved to report. Anybody here have any concerns before we move forward? I speak for and opposition to this.
Mr. Chairman.
It's been heard. Senator Reeves.
I thought there was a standing tradition in the committee that we didn't take action on pending legislation that was currently before the courts. And I think if we make an exception in this case, we're violating that. And for that reason, I'm going to vote no.
All right, and I don't know whether the Attorney General's office or Ms. Maxwell wants to address that before we move to a vote.
Mr. Chair, I can just briefly address that, and I think the AG's office could as well. Primarily, we do understand the concerns. We just, in this particular situation, given that the judge has given such a strong indication that she will likely rule the statute over unconstitutional, and given the time delay between this session and the possibility of having legislation enacted the next session, we're concerned that in the meantime, there could be, between the judge's ruling and the next session, proliferation of signs in the right-of-way, which could create significant safety issues, as well as could potentially jeopardize federal funding if the feds were to deem us to be, or to not have control over rights-of-way on federal aid primaries and interstates.
And we talked about this briefly last time, but, I mean, is this a problem in more than one county in Virginia?
Mr. Chair, the lawsuit itself involves one entity that was placing signs in the right-of-way in one locality.
County.
Yes, sir. Yes, Mr. Chair.
Who's that? Who's that? Where was it?
Mr. Chair, I'll let the AG answer that question. I'd be more comfortable.
The realtors are from Fairfax County, Senator. It's Bruce and Tanya and Associates are the plaintiffs in the matter currently pending in the
Are
Eastern
these
District of Virginia.
the great big signs or just the little?
Popsicle signs.
Right,
Mr.
but
Chairman.
it wasn't a problem, okay.
Mr. Chair.
Hang on, Senator McDougall, then
Chairman,
Senator Peterson.
This might fix some of our issues with our ability to obtain wireless technology.
All right, Senator Peterson.
Mr. Chair, I was just going to say, first of all, proliferation of signs in the right-of-way is a safety hazard, and especially was in our part of the state. Secondly, I'd simply say on this pending litigation issue, in the words of the immortal Jimmy Buffett, it's 5 o'clock somewhere. So there's always a case that's going to be potentially implicated by legislation.
Mr. Chairman, if I may. Mr. Chairman, if I may.
Yeah.
I would also just, to Senator Peterson's point, SB 181, which was passed out of committee and by the Senate this term, also had a litigation that was dealing with that coming out of the Western District and currently still pending in the Fourth Circuit, to Mr. Reeves' concern. So that there has been a case before where the committee.
What was that bill?
That was dealing with the suspension and fines dealing with licenses.
Okay. All right, It's been moved. Is there a second?
Second.
All right, it's been moved and seconded to report the
Mr.
bill.
Chairman?
Yes.
There were discussions. I thought that the proponents of the bill wanted the emergency clause taken off, but I'm not sure if that's still the case or not.
Mr. Chair, that was one thing we wanted to mention, that if we took that off, and this is for the committee's consideration, that perhaps it would remove some of the reluctance or the perception that we are somehow trying to sway a court. But if that's not the case, we will leave the emergency enactment on there.
Well, if I, I'm not going to give you any advice. So you want to leave it on?
Mr. Chair, I think it might be best if it's taken off. And then that way, if...
Probably a wise choice.
And there obviously are other issues as well, but seriously, Mr. Chair, if that way, the bill would not go into effect until July 1.
All right.
By then, we are certain that the court will have ruled.
Mr. Chair, Senator Edwards withdraws his motion. I'll move that we amend the bill to withdraw the emergency clause.
Did we adopt the emergency clause?
No.
It's not on. Oh, it is?
It's on the bill.
Oh, okay.
Is it on the bill?
All right. All right. With that, without objection, the motion report is withdrawn. Senator Deeds moves to strike the emergency clause, seconded by Senator Edwards. All in favor of that amendment signify by saying aye. Aye. All opposed. That amendment's made. Senator Edwards moves. Senator Deeds seconds to report the bill as amended.
Mr. Chairman, can I ask one more question?
McDougall.
Realistically, Joanne, when do you think that the court would get to a determination factor? I mean, I think some of us are sympathetic to the issue, but have real concerns about our longstanding tradition. And so knowing how long this might potentially be an issue would be important.
It will certainly be resolved by July 1, either through motion from the plaintiff or on behalf of the Commissioner of Highways. We'll move for summary judgment. That much
Mr.
is...
Chairman, let me restate. If this does not pass, when will the case be resolved?
One way or the other. This is going to go to summary judgment before the court. My guess is end of March, no later than April, which point I expect the court to make a ruling.
You expect a ruling from the bench?
In my experience,
at the hearing?
In my experience in the Alexandria Division of the Eastern District, that's about 70% of the case, with a memorandum opinion to follow. Brinkema.
So we could take this up in our conversations throughout the spring.
Mm-hmm. All right. Motion properly seconded to report the bill as amended. Clerk will open the roll. Closer. Got a vote?
Ayes 8, no 6.
That was a good call, taking that emergency clause off.
Thank you, Mr. Chair.
Smart move.
All right. All right. Delegate Adams. We took up one of yours. We've got, or two of yours. I guess we've got 1301.
Yes, sir. Thank you, Mr. Chairman. I think that's all that's left, and thank you, committee, for acting favorably on the other bills. The House Bill 1301 would require that judges be subject to the central registry background check for founded complaints of child abuse or neglect. You know, currently there's a criminal check, of course, but apparently this has not been done and needs inclusion in the code. This was requested to be carried by Chairman Bell in courts and I'm not sure how this was discovered or came about. I don't think it's on a recommendation of the Crown Commission. It may have come through some of the work there, but there's no fiscal impact on this bill according to the
Mr. Chair.
latest statement I received.
Senator Deeds.
What is there a problem? Is there a judge out there that has gotten through the whiz process we have here in the General Assembly that somehow abuses children?
Right, not to my knowledge.
Okay.
Well, Mr. Chairman.
Senator Edwards.
There is, hate to be ultra technical, but a conviction is a conviction, but founded is not a conviction.
Yes.
And it could be, a lot of people would contest that it's properly founded. A founded complaint is an administrative process that might even be wrong. And so is this just a politically correct bill or what?
Well, Mr. Chairman, just in response, I certainly concede that point that founded complaint could be wrong. In my view, this would be a good policy choice for the Commonwealth to make in terms of knowing what we ought to know, in terms there is a process for founded complaints of child abuse. I think if there were candidates before us who had been through that process and been found that, I think that would be relevant to the Assembly.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, it seems to me this is another piece of information that the members of this committee and the one down the hall would have before making a decision. One of the things that I became aware of this week, in addition, we do not require economic disclosure statements for individuals in their initial venture to try to become judges. Once an individual has been elected a judge and they're going forward for re-election, we require economic disclosure statements to be filed, but we don't require that on the front end. So I would suggest that we amend this to say they go through this check and file an economic disclosure statement before being considered. Because I think Delegate Adams makes a good point. This is something, we ought to have information before making those decisions.
Thank you, Senator.
All right, is there a second to that motion?
Second.
All right, it's been moved and seconded. Kristen, you have that or in concept? All right, all in favor of adopting that amendment? Well, Delegate Adams, do you have any problem with that?
No, Mr. Chairman.
All right. All in favor signify by saying aye. Aye. All opposed? All right, that amendment is adopted. Anybody in the audience opposed to this? All right, it's been moved and seconded to report the bill as amended. Clerk will open the roll.
Ayes 12, noes 2.
All right, thank you very much.
Thank you, sir.
All right. So we've got 3 more bills. None of them are simple, are they? I guess, no, what? Here's, I think Delegate Gilbert may be close by. I see his body double out there.
Mr. Chairman, we could probably take up 1193.
Okay. 1193.
Mr. Chairman, House Bill 1193 provides that a person who is acquitted by reason of insanity of an offense and convicted of another offense must serve his sentence for conviction prior to being committed for inpatient hospitalization on the insanity
This is really wacky.
defense. So it's just a policy consideration of a person serving his time of confinement on his guilty plea first, and then serving the time on the insanity
Mr. Chair.
second.
Senator Deeds.
If I could ask Charles a question, doesn't this address an issue that was raised recently in court or maybe in an appellate court?
Williams versus.
I believe it does, yes.
What does that case say?
In that case, Mr. Chairman, the circuit court had ordered that the defendant serve his sentence first and then be transferred for treatment. The appeal contended that this was an abuse of discretion and a grave injustice. The Virginia Supreme Court held that it was not.
So this basically confirms the Supreme Court's ruling, the statute?
It is not inconsistent with the Supreme Court's ruling.
Requires that He's served his.
I suspect that the point of the bill is that it's unclear. Well, currently, I think the circuit court would have the discretion to order treatment first and then sentence, or sentence first and then treatment. And so the question for the committee, if I understand the bill and the state of the law, would be, do you want to make it only one way, or do you want to leave it with the sentencing court? And and the policy factor for the court, for the committee to consider is, should the circuit court judge, who may be in the better position to say whether somebody needs immediate treatment before being transferred to DOC, maybe they should be permitted to retain that discretion.
Yeah, Mr. Chairman.
Senator Edwards.
Yeah, I think absolutely. We don't need the bill. It's what the Supreme Court apparently said was we'll leave it to the circuit judge's discretion.
Well,
and it seems to me further, probably the Court of Appeals was, it's hard for me to say this occasionally, but it was maybe right, that you got somebody who's ruled insane, he needs treatment, so you lock him up before he can even get any treatment.
Before Delegate Bell's aide has cerebral hemorrhage out there, why don't we suspend on this and let Delegate Bell, I know that he and Delegate Gilbert are tag teaming on courts, and I think one or the other is on their way, and I know that they're tied up. Theirs are the only bills, theirs and Delegate Yancey's are left. So let's just give him a, yeah, sure. Senator Sasslaw.
Mr. Benjamin. Question. A guy goes into a store, a 7-Eleven, and he holds up the cashier, gives him I don't know, now he's got to give him more than $500. I don't know. Anyway, so he gives him $600, and then he decides, hey, this guy can identify me, so he axe murders him. So they can rule. I mean, I'm not a lawyer, so I'm asking you. So they can rule that he wasn't insane when he took the money, but he was insane when he axe murdered the guy. So on that basis, what I guess the judge could say is that you were sane when you robbed him, so you got to go to prison for armed robbery, and when you get out, we're going to send you to the insane asylum or whatever they call these things these days. Is that the way the situation is or occurred?
Mr. Chairman, it rarely involves an axe murder in a 7-Eleven, but
all right.
But
I was trying to clean it up.
But Senator Sasslaw is
which
correct.
Is rare for me.
That a person can be acquitted because of insanity at the time of the offense,
right.
Yet be convicted of another offense because he was not insane at the time of that offense. And that results in an individual being sentenced to a term of incarceration, but also being committed for mental health treatment if he is found to be a danger to himself or to others. And so the question is, who should determine where he goes first? Should he necessarily serve his sentence first and then be treated, or should it be left to the discretion of the circuit court? That's the question, I think, that is presented by the bill, right. But the patron may have a different take on it.
So within a period of 1 minute, it's possible to go from sanity to bonkers.
Well, theoretically, but no, I've never seen that.
All right.
Mr. Chairman.
Okay.
All right. We'll suspend for a few minutes until one of our patrons arrives.
Was it a discretionary decision?
93, and we've been talking about the necessity thereof. I think that
So this is purely a technical bill. It was a comment made in the Williams case by Supreme Court Justice Mims, who said, we'll guess at what we're supposed to do here, but really we would appreciate some guidance from the General Assembly. That's all it is. And it's an issue when you have a, if you will, a correction sentence and you have a period of time you're going to be placed in a mental health institution. And literally it's just what order, how do you apply? And it would be, so you might have it come on different, on July 1st you get sentenced for one, on another previous case you've been found in GRI, or it could be you're in an institution, commit a crime. Those are the fact circumstances. I see Senator Deeds looking puzzled.
Yeah,
Senator Deeds.
Mr. Chair, the only thing I wonder,
Right.
since mental health is such an individual thing,
Right.
it affects different people different ways, why wouldn't you leave it in the discretion of the court to figure out what's best for
They just wanted the
individual?
order. Which one do you do first? How do you stack them? My initial thought was, let's get your mental health right and then serve the sentence. They actually preferred it the opposite, which would be
Mr.
they had
Chair.
DOC
Please.
and DBDHS, whatever those letters are.
Sir-
They
Senator-
considered both ways, and they said we prefer to be the last one you see, because if we've got you mental health better, we've got an exit plan. We'd rather do that last before you then go to jail, and we kind of lose whatever benefit that we've had. And that's that. Aside from that, I've got no emotional investment in this bill. Just trying to fix a problem that was brought to the.
All right.
General
Any
Assembly.
other questions? All right, the bill's before us.
Mr.
Charles?
Chairman, there are two technical amendments. On line 46, it says pursuant to this section. That should probably be pursuant to this chapter. And the same amendment on line 51, that just deals with the release, and it says pursuant to this section, and this section does not deal with release. Release is in a different section in this chapter. So those are the amendments.
All right, is there a motion on those amendments? It's been moved and seconded. All in favor signify by saying aye. All opposed? All right, the bill's before us. It's been moved and seconded. The bill be reported. Clerk will open the roll.
Ayes 7, noes 5.
All right, the bill's reported. Thanks.
Mr. Chairman, just to try to keep the trains running, I believe both you and Senator Norman have bills on the court side that don't need you to be present unless we send you a text message. They look to me like they're both things we've taken up in the past. And I'm looking at the membership. And we're sending Stanley back briefly because he had something that was worked out. So I think.
We don't need him either.
I will stall him. We'll work on that amendment at great length.
We're just looking for Gilbert and Yancey, and I think both of them, I think
We can
Gilbert's
send
waiting
Gilbert
for
up.
you to get back,
Yes, sir.
and Yancey's presenting a bill.
In
so
transportation. Yes, sir.
he'll
Thank
be
you, sir.
Up
Thank
here
you.
presently. Thanks. We'll suspend. Your bill, House Bill 1525, which is a fine bill dealing with the use of personal handheld communication devices in highway work zones.
Thank you, Mr. Chairman, and I apologize, I just got out of Senate Transportation.
Not at all. A lot of things going on.
Never a dull moment around here. Simply put, House Bill 125 would impose a mandatory fee of $250 for using a handheld personal communication device while in a highway work zone. So for an example, on the I-64 on the Peninsula Widening Project, if a person was in the construction zone and they were texting on their phone, they would obviously be charged accordingly.
Delegate, a couple of things, and some members may have some questions, but I'm given to understand that this is subsumed in, I think, Delegate Collins' bill, and which is on the floor now. And if yours reports out and Delegate Collins' bill passes, it may very well be that this will wind up simply drifting out to sea or being recommitted because it's already taken care of. So just wanted to let you know that. And there's some diversity of opinion about this, so we wanted to give you an opportunity to make a pitch before we voted on it. So sorry to drag you up here.
No.
Anybody have any questions of the patron? Anybody in the audience have any concerns?
Mr. Chairman, the only
Senator Edwards.
question is the mandatory fee as opposed to punishable up to $250.
That's the point, right.
Didn't we already pass it, according to the note?
And Collins' bill,
We had the mandatory fee.
it is. So
I'd like to,
bill
why is it
passes,
mandatory?
this is-
I'd like to make a motion that would say up to as opposed to mandatory.
Well, we've already passed the mandatory fee in Delegate Collins' bill.
Well, we can reconsider that with this bill. I'm not sure we caught that
Don't think
last
we
time.
can reconsider.
Anyway, that's my motion.
Right, is there a second to Senator Edwards' motion? Hearing none,
Did you say it?
no, to amend. All right, the bill's before us.
Second.
It's been moved and seconded to report the bill. Clerk will open the roll.
Yeah, there's going to be, I'll just say no.
Hang on a second.
There's going to be,
Trying to figure out which one's next.
In the work zone, John.
yeah, that's true, it is, yeah.
It's limited to work zone.
Well,
You're still good.
Ayes 8, noes 5.
In the work zone for 250.
All
Mr.
right.
Chairman, members, thank you, and if the bill goes on a nice journey around the world, I hope it visits some nice ports of call. Thank you.
All right, thank you.
In the work zone, I don't know.
All right, we'll be at ease till Delegate Gilbert arrives.
How many people aren't paying?
All right, tell you what, let's go ahead and act on this. And Senate Bill 986, Senator Norman moves, Senator Reeves seconds the adoption of the substitute. All in favor signify by saying aye. Aye. All opposed, substitute is before us.
Mr. Chairman, I have an amendment.
I'm sorry?
I have an amendment. Yeah.
An amendment to the
well, let's see.
substitute?
What's this amendment about?
On the foster care bill?
This is the one, yeah, with foster care. Yeah, the issue is this, Mr. Chairman. We're doing it.
Well, why don't we start by letting Kristen explain the bill?
Okay.
And I think we've got a couple of line amendments, and then we can take up your amendment. Okay, Kristen?
Mr. Chairman, this bill, Delegate Gilbert's Bill 986, would require that local boards of social services provide foster home or residential facilities all known information, including whether the child to be put in the foster home is a perpetrator of sexual abuse. And it requires the same information be provided to prospective adoptive parents. The substitute makes a few amendments. We, during work group, were concerned with the language, all known information, in regards to the foster care, because we didn't know what all known information was in reference to. It's clearer in the adoption section. It says that all known information regarding whether the child has been a perpetrator of sexual abuse. So we sought to harmonize that language by using the language that was put in the adoptive care section in the foster care section, and you can see that in the substitute on line 69. The other question that we had in work group was how you would know if a child was a perpetrator of sexual abuse. Did there have to be some kind of a complaint? Was it just a rumor? So our suggested language was including whether the child has been the subject of an investigation regarding sexual abuse, which you can see on line 70 and 126 of the substitute.
Okay. All right. So the substitute has been explained as before us. Senator Edwards, you have a question?
This may solve the problem. A lot of times these children have been the victims of sexual abuse, and that creates a lot of problems, and this may cover this. Good, that's fine.
All right. Is there a motion to, anybody in the audience have concerns about this bill? Kristen, you aware of anybody who objects to this? All right, the bill is before us. Second. All right, it's been moved and seconded to report the substitute. Clerk will open the roll. All right. Before we rise, I just want to say that we have, I'm sorry, did you vote? All right, did you announce the vote?
Oh,
sorry.
Ayes 12, no 0.
And that's it, right, Kristen? Yes. All right, before we rise, we have gone through 339 bills this session, a really incredible number, and we couldn't have done it without our council's help. Kristen, Charles, Steve, you all fantastic. Really appreciate your guidance, and you all did a great job. The work group, none of whom other than Kristen, Charles, and Steve are here, but Jim Plowman, Maria Jankowski, and there we have the Crime Commission. And Colin was absolutely unbelievable, putting together notes every week and diligently taking down those concerns. So thank you, Colin, for your assistance and service. And then finally, Hobie, Rachel, and Griffin, thank you very much for staffing the committee, and to our pages, thank you all as well. So let's give staff, our council, and pages a round of applause. Well, thank you very much, and with that, the committee shall rise.